We're continuing with the Peace, Crime, Sentencing and Courts Act of 2022. There it is, 209 sections, 21 schedules, and it received royal assent on the 28th of April last year. The whole of the Act didn't come into force with royal assent, so Section 208 is your important commencement section to read. It brought many important provisions in force on the 28th of April last year and also the 28th of June. We've also had a number of statutory instruments concerning this piece of legislation, by which the far most important one came out really as Statutory Instrument 2022 number 520. There are some sexual offences, aren't there, that don't carry anything like 14 years, and yet they are still deemed to be serious offences under the Sentencing Act 2020. Remember, the sentencing section of detention for a Crown Court judge on a serious offence is Section 250 of the Sentencing Act 2020. Your list of serious offences is contained in Section 249 of the Sentencing Act 2020. There is no bar to committing a youth for sentence to the Crown Court, but it must be one of those serious offences, the committal section being Section 16 of the Sentencing Act 2020. This may produce a result unwanted by the defendant, a trial in the youth court when he really wants a trial in the Crown Court. But he has no say in the matter. A trial in the youth court and a committal for sentence. The youth has no right of election, unless, of course, he's in the youth court on an offence either way, and he becomes 18 prior to plea. In those circumstances, you treat him as an adult, albeit he's in the youth court because he's now 18, and you deal with allocation and sending.